Welcome back to Canadian Justice, where we're discussing a case headed to the Supreme Court about the scope of police search powers. The case is called R and Singer, and it involves police who entered the private property of a man, and they found him in his vehicle unconscious. They looked in the windows and opened the vehicle door without a warrant. Is that an unreasonable search under the Charter? Now, the Charter does guarantee the right to be free from an unreasonable search, but it does have that preface, the word reasonable. So, Annamaria, what makes a search reasonable or unreasonable, and how might it apply in this case?
So before I go to that question, the issue in Singer actually precedes the inquiry of whether or not the search is reasonable or unreasonable, because the Crown and the police are arguing that there isn't even a search in this case to be determined to be unreasonable. They're saying that no search exists because there's an implied license for the police to do exactly what they did, and as a result, they're saying that the other inquiry, which is the where most of the work is usually done in these kinds of search and seizure cases, the determination of reasonableness is not even required in this case. But once we've determined that a search has taken place, then the question is whether or not it's reasonable. And the Supreme Court is clear that all searches that are warrantless, so unless a warrant is granted, are unreasonable. So you have to have a warrant in order for a search to be reasonable, but there are some exceptions. For example, the exigent circumstances doctrine, where you see somebody, classic example with a bloody knife running into a building that's locked. The police can go into that building because there are exigent circumstances. There may be someone's life at risk. So there are small exceptions. And also there's the ancillary powers doctrine, which recognizes sort of powers that emanate from the police's authority to enforce the law and to investigate. But again, those have to be circumscribed because they are exceptions. So the gold standard in Canada for whether a search is reasonable or not is, was it conducted pursuant to a warrant?
And in this case, it wasn't. So, look, I do think that impaired driving is a serious social problem. It kills people in this country. It's a criminal offense. Police do need to have the powers to investigate impaired driving offenses and charge people with the crime of impaired driving. In this case, that's what Mr. Singer was charged with. What could the police have done differently in this case to investigate their crime? Could they have obtained a warrant? What should they have done in these circumstances rather than relying on this implied license to enter his property?
Well, that's an excellent question. And it's one I think that's at the heart of this case because there is very little else that the police could have done, given that they didn't form reasonable and probable grounds to believe that this person whose property rights they are violating has committed any crime. They had some suspicion, but it didn't amount to enough. And the Supreme Court of Canada has told us that that nature of suspicion is not enough to trump an individual's liberties, particularly when it comes to their own personal privacy. When it comes to impaired driving, our laws have recognized that this is a scourge on society. And so a lot of the Highway Traffic Act laws and criminal code laws give police powers to search not only a person's car, but their bodily fluids where they have suspicion of criminal offenses. So the powers that police have generally to investigate impaired driving are much broader than in other contexts. But in this context, the police had nothing more than suspicion, and we don't accept suspicion as a grounds to do anything when it comes to searches.
Now, there is some existing case law on this implied license that the Crown is relying on here. What does the existing case law tell us?
Well, some of the existing case law, I think you're referring to a case coming out, case from the Court of Appeal of Ontario, and in that case, the police recognized that there was or the court recognized that there was an implied license to search in very similar circumstances as the one that is before the court. However, the police had a stronger reason to believe that a crime was taking place, had taken place. And so in that circumstance, it's not just the facts that are parallel, but we have to look at what the distinguishing features of each of the facts are. And in that case, the individual individual, the police had a lot more to go on than merely a person with their car running in their driveway.
Yeah, suspicion just isn't good enough in a case like this.
Yeah.
We've got to go to commercial break now, Anna Maria, but when we come back, I want to talk about what other jurisdictions, yeah, how other jurisdictions like the United States treat this implied license. We'll be right back.